Hi guys, it's Kathy. I hope you're doing well. We made it to Tuesday. Man, I work today. Ugh. It's fine. It'll be a good show. So, guess who's back? Look at that. He started streaming again. Yes, sir. He's not the one who said don't look at her, though. He's a different one. That's another clip. So, we're going to start with Judge Nathan, though. Hi, Lacey. Because I do love Judge Nathan. I left it in because I do love me a good ponder. He does take pondering to the next level, though, today. How did you know it was One Piece? Yep, that's One Piece. I love One Piece. I love Luffy. Luffy makes me so happy. One Piece is a anime. It's really long. So if you're going to watch it, you got to commit. But Luffy makes me so happy. Oh my gosh. Okay. Let's get to Judge Nathan because we haven't seen him in April 9th, I think, was his last stream, I think. Like April 6th. I don't know. I can't remember everybody's last stream. Here we go.
The parties here on cause number 2026-19333, Whitmire versus Midland Mortgage. How about cause number 2026-32376, Foster versus Foster?
I'm Jacob, representing the defendant, Al Foster. He, I believe, is on Zoom. He is in Mexico at the moment. He's back Monday.
Mr. Foster, is that you on Zoom under the heading Texas?
That's correct.
All right, come on up.
Good morning.
Good morning. Okay, former spouses dealing with the balloon business and it's not working out well, right?
Correct.
Okay, tell me why I should enter a restraining.
So, Your Honor, the parties got divorced, and and part of the decree and their immediate settlement agreement, which is incorporating the decree, the balloon business, they were going to try and run it together, and then neither one of them reserved the right to be able to buy the other out, which is part of the basis of the foundation of the lawsuit. During the process of this business, Mr. Foster has tended to primarily relocate to Mexico. He's not participating in the business. They had a big client, the Texans was a big client of theirs. He has not been attentive to any of the work that's being done, may have lost that client. Their warehouse had some issues. It wasn't locked and secured, wasn't letting my client know. And then things escalated and got a little heated. In the sense that she was trying to reach out to him. She was trying to talk to him. He has threatened her. She has filed a complaint with, and I have the number here with the district attorney's office, and they are charges for terroristic threat. He said he has a gun with a bullet with her name written on it. This is the charge. They are taking the charges for terroristic threat against him for that. He has shown up at her house, banging on the door late at night, thinking that she had some other man in there, banging on the door saying he wanted him to come out. He was going to talk to him, threatening her. He's been very violent and aggressive towards her. So part of the issues, Your Honor, is right now he's not even in Texas. He's not participating in the business. If he does participate in the business, he's not communicating with her about the business. They're losing some jobs. There's a lot of stuff that's going on. He has threatened her, and he has come to her house very angry and aggressive. And so she is scared of him and of the threats that he has made. This is not the first time that he's made a threat with a gun that he was going to kill himself. During the marriage, there were some issues with him putting a gun to his head, saying he was going to kill himself and threatening to kill her along with him. So this isn't the first time this isn't like an isolated incident. He does have these anger and aggression issues. We want a temporary restraining order because there's business that is falling through the cracks. He has the phone number for the business and the cell phone for the business. She's not able to reach a lot of the people, a lot of the clients. They have a joint app that they use to communicate with everybody together, with the employees and everything. When she asks them questions, he's just not responding. She has a chance to salvage the business that can make very, very good money. She just needs to be able to have control of the business to be able to make this work, and so that they can proceed forward in the 269th and her buying out the business.
May I respond?
Sure.
So Judge, all of these complaints came about when my client got remarried in March. Suddenly, there was a lot of problems with the business. Not to mention some $46,000 that the applicant, the plaintiff, has actually took out of the business in February without discussing with my client and put into a personal. There has been no loss of business. There are 2 full-time employees who set up these balloons. My client has not missed a single phone call or work order from clients since he's been in Mexico for the last week visiting his wife, who's having immigration problems. That's the only reason he is down there. He met with me the week before last, and he's coming back on Monday. He's not relocating to Mexico in any way. He's got an immigration lawyer who is contesting the immigration status to Texas from Mexico. Apparently, in this political climate, that's the only place you can't immigrate from right now without issue. There is no problem with the business other than a slight downturn in the operating flow, which is as a whole part of the economy. There's been no showing of irreparable harm. There's been no showing that there's no adequate law that would not be satisfied. Frankly, I'm not even sure that they'd actually pled a valid cause of action here. And the divorce decree needs to be clarified by the trial court, as it is extremely unclear and poorly written based off the agreement as far as how a buyout would occur when both parties want to buy the other party out or dissolve the company. The cell phone in question is my client's personal cell phone. It has been his cell phone since before the company was started. He has not failed to actually connect with any potential or past business. In fact, most of their clients have said that they flat out refuse to deal with the petitioner. They only want to talk to him. Her role in the business has been as the bookkeeper, and he is the front man. With regard to the storage unit in question, there was a week where the storage unit, it's a roll top, door within a large storage facility, where it had come off its hinges, and they had to, the storage company had to actually, took some time to actually fix that. Meanwhile, my client built a wall behind it as soon as he knew, that there was a more than a 6-inch gap. The affidavit attached contradicts itself in more places than I can count. And there's been no showing here of actual irreparable harm. There have been no threats of violence that have actually been made or substantiated. My client did go over to petitioner's house on or about April 11th to get some documents she wanted him to fill out, and he left, and that was that.
That was that. 7 Stream Street, great. Granny, thank you so much. But more importantly, how cold is it in your house right now? Does everything work fine? Does your air conditioner work again?
If I may respond to a couple of comments.
I'm not finished. Frankly, the causes of actions that are pled here are a breach of fiduciary duty and breach of contract and a failure to deal in good faith. Well, there's no showing here that Mr. Foster has breached his fiduciary duty in any way by breaching the duty of loyalty. There's no showing that he has self-dealt, that he hasn't put the business interests above personal gain, and that in any way he has failed to be transparent. With regards to the app that is used by the 2 employees, Mr. and Mr. Foster, it's some sort of Google Calendar that they all have access to, and there's a group messaging thread. So to deprive him of his cell phone, I'm not sure how that would actually be, an equitable relief that this company could, while we're waiting to dissolve it, set up another phone number. There are allegations in here that since Mr. Foster has been in Mexico, he hasn't answered or been able to answer the cell phone, which is not true. And the voicemail on the cell phone actually directs him that if you need immediate help, please call one of their employees at his gives that cell phone number here. Lastly, there's been no showing of an actual decline in business year over year by the plaintiff. She makes allegations that right now she should be reimbursed $50,000, but it doesn't substantiate where that comes from. And frankly, Judge, this sounds like an issue for the divorce court to sort out with the issues from the final decree of divorce.
Do you have a proposed order?
I do. It's been filed with the court.
We don't have one.
Maybe it's still pending. It was filed. It just needs to be accepted there. And Your Honor, we do have a recording of the phone call where he threatened her. If you want to see it, we have a transcript of that recording. If you would want to look at it.
I would also like to look at it.
Here's this.
Okay.
And this is a copy of it. So if you need to. One last thing is he did say that she took money and she was transferring it without his knowledge or consent. They had an agreement was signed by both parties to show that she's trying to do everything she can. She's getting everything in writing. She just has no contact with him.
All right, guys. Now we ponder. He's reading the transcripts of the cell phone text messages or phone call or both that she submitted and all the other documents. And this is a ponder. He does look annoyed, doesn't he? Thank you, Jude.
Man, is there any way you can do another proposal here? Not say that it's the e-columns.
Yes.
I didn't call it that. I have the calls and the times he showed up at my house yelling and screaming in the middle of the night. I'm not safe.
She's talking to his lawyer. And her lawyer's just standing there letting her.
Can you listen to the videos and the calls? Because I'm not safe.
It's okay. She's ignoring too. Katie's ignoring too right now.
Sure is, Michael. He's not done. It's confusing because they sort of lumped a whole bunch of things together. She's here for a protection order against him, which has nothing to do with the business and him not answering his phone, except she did ask for his cell phone. She wants his cell phone. So that's what she has in the protection order, that he's not allowed to contact her and he has to give her his cell phone. That's his personal cell phone.
This, she did it. Yeah.
Preparing for a podcast that you won't be on.
Yeah, and my
Sorry, Judge.
No, true.
And one last thing, Judge. In response to this agreement on February 25th, 2026 regarding these funds, the funds were originally withdrawn prior to that by almost 2 months to an unknown checking account here.
Legally, though, what does that matter, sir? They both legally own the business. They both can take money out of it. Legally, that doesn't mean anything. We're here for a protection order. She just presented a judge with a video and text messages from your client. Maybe you should focus on that, because that's what the judge is focusing on right now.
It was not a business account. I miss Foster.
Novi, actually, I think she wants it because he left her and got married to someone else. his wife is in Mexico right now, or I think Mexico. That's why he's in Mexico to visit his wife, or a different country. And I think she's jealous. I don't know, though. I don't know.
Oh, thank you.
Nailed it.
T, that's a damn good question, just so you know that.
See you after.
Okay.
It was filed last night. There was something filed last night, and something different filed this morning, but I'm not sure if they're the same documents.
Same document.
Okay.
I miss Judge Eric so much. Don't worry, guys. He's done pondering. It's over. Now he's going to give his decision.
Thank you. Thank you.
He always pulls everybody up to him. I don't know why.
So, can you tell me when Judge Sepolio does his hearings?
In 12? Yeah.
Granted the TRO, I've set bond in the amount of $1,500. Judge Sepolio will handle the temporary injunction hearing June 12th at 12 p.m.
Thank you, Judge. Maybe the excuse.
Judge, are you making a finding that my client has moved to Mexico?
I have not.
Okay, so I'm not sure if that's the same order. This is page 2. All the findings.
I have taken that out. I have also taken out the order turning over the phone.
I'm sorry, Judge.
I've also taken out the line about turning over the phone because it sounds like it's his personal phone.
Okay.
And just like that, no fanfare, no talking, no nothing. Boom. She gets her protection order because she brought receipts.
So on the record on 3 cases, 19 CR 2947, 24 CR 1564, and 26 CR 781, If I can have appearances as to all three cases, please.
Jacob Cram for the people.
Good morning.
Mercedes Prevey on behalf of Mr. Joshua Barkat, who appears in person in custody. I would note the alleged victim is here, Georgia, sorry, I can't remember her name. Cousins, yeah. Cousins, thank you. Miss Georgia Cousins, and she does want to address the court as well.
Okay. All right. I'll note that the 19 CR and the 24 CR case are both set for a status today. I believe Mr. Barkat is on probation for those cases. And then I think it's the first initial arraignment on the 26 CR case. So, Ms. Prevey, have you received the fourth amended complaint for revocation of probation in the 24 CR and the 19 CR case?
Yes, Judge, I have reviewed it. It does look like the court didn't serve me. I would just ask in the future if the court can make sure to serve me. It looks like the court only served the people on that notice.
Okay. Do you waive formal reading and advisement?
Yes, and we would like to address bond, please.
Okay, go ahead, please.
Thank you. Looks like the court currently set bond on each of those cases is $100,000. Previously, the bond set on both of those cases with $10,000 cash or surety. Understanding the concern the court and the people have regarding the new allegations, we would ask that the court not raise bond from $10,000 to $100,000. We understand that the court and the people are probably requesting some increase in that bond. Mr. Barkat has been on probation for some time. As the reports show, although he picked up a new charge, he has been compliant with other requirements of probation. That includes taking his UAs. Although his last positive UA was back in May for THC, he does now have his medical marijuana card, and that was provided recently to his probation officer, so there should be no further issues with THC and probation. Otherwise, there hasn't been any other substances positive for those UAs. Mr. Barkat has been compliant with meeting with his probation officer. His last meeting was on May 19th, and he did attend that meeting. I did also speak with his probation officer, and I verified that information that he has been keeping the meetings, keeping in touch, and doing the best he can with UAs. I know the report lists that Mr. Barkat has not re-enrolled in domestic violence treatment. He does need to complete a new intake. The new intake does require that he have $225 to pay for that new intake, and then money saved up for the treatment, plus the outstanding fees for the previous treatment. He now has saved that up, so he was ready to pay that $225 to get that intake started. So he has been working to save that money and not just ignoring that requirement of the court and probation. Just some general information for the court about Mr. Barkat. He's lived in Colorado his entire life. His whole family lives here. He's living with his parents. They are supportive of him. His dad is a pastor, and encouraging for him to get into treatment and comply with all court orders. He is fully employed. He does glass work. He does have two children who are ages 10 and 8. Those children are not shared with Ms. Cousins, the alleged victim in this case and the new case that's listed in the complaint here. He does have shared custody of those children. He's very involved in their lives. I know he talks about them frequently with me, as well as has frequent visits with them weekly. He also provides financial support for his children, so it's very important that he remain out of custody so he can provide that financial support and continue working. I would note that although this is listed as a fourth complaint, the third complaint was withdrawn due to an error. That was something that I actually had to reach out to the probation office and tell them that they had a case associated with Mr. Barkat that he was not arrested on, that his name never appeared on, and some other random individual appeared on that. So understanding that there still has been multiple complaints here, that third one wasn't just withdrawn because probation decided not to go forward on it. It was withdrawn because there was no new case that led to that. And I actually pointed that out to the probation office and asked them to file that. When there was that warrant for that third complaint, I did advise him of that, and he was prepared to turn himself in on that warrant. However, we were able to get the probation officer to agree that was an error. As I noted on Friday, June 5th, he was here in person. I did speak to him about these warrants, and he was aware of them in the hallway. We were planning to address the warrants before the court on Friday, and then he was remanded by the deputies. And so he did show up wanting to take responsibility and address these warrants, understanding he was most likely going to be arrested since there was those new case allegations. The new bond in the new 26 CR case, not before this court, was set this weekend at $75,000 cash or surety. That's a pretty steep amount for him to pay. So we'd ask for minimal increases in what was currently posted as the $10,000 cash or surety bonds.
Right. I see that Ms. Taft is here present virtually. I know Ms. Cousins is here present in person. Mr. Cram, what's the people's position, sir?
Your Honor, I would ask to
What's the charge of you calling your employee stupid names? Like what? I know legally that can't be right, but what is it? What's the charge?
keep bond as the $100,000, understanding that in the most recent case it was set at $75,000. My main concern here is the amount of pending revocations that we have. More importantly, the fact that we have 7 active domestic violence cases with multiple different victims. He continues to pose a danger to both the community and the females that he dates intimately. He continues to put them at risk, and this was caught in public. The new charge, I apologize, was caught in public on security cameras. If he's willing to commit these activities while out in the public, the people do fear what he is willing to commit in private and behind closed doors. He continues to pose a danger, and I do believe that our named victim, Ms. Taft, as well, would like to address the court just for the court's awareness. Nevertheless, I think a higher bond, or as high as the court is willing to set it in this case, is more than appropriate given the amount that we have in front of us today.
Okay, give me just one moment, please.
When he said, "Give me a moment, please," that was like 5 minutes he sat there. So I just had a nice healthy ponder in the last video. So I was going to leave it in, but I cut it out. It's gone.
Right. Apologies about that.
All right.
Ms.
That's
Taft,
right.
I don't know if you can hear me, ma'am.
I don't care what they call me.
There you are. So you don't have to say anything, but is there anything you'd like me to know or consider when I'm addressing a bond today?
Yes, Your Honor, I would like to say my concerns to the court. Thank you for giving me your time. Just kind of reiterating what the DA said. This is a fourth time, this is a fourth victim of domestic violence, and May of last month marked the 2-year mark since I fled Colorado with my family to come to California so I can safely be away from Joshua Barkat. And I'm just now getting back on my feet, dealing with the aftermath of all the pain and destruction that he caused, both physically and emotionally. Now that I'm back on my feet, I feel ready to be part of my part in the case and address the court and stand up for myself. I also feel like it is my responsibility because I'm the only one that is far enough away from Joshua that he can't intimidate me or hurt me for speaking up. I don't think that can be said for the other 3 victims, which is why I feel like it's my responsibility to be here and say something. And I would also like to add that I have still been contacted multiple times as of this year, including Friday, by either a family member or potential partner, which I will also be providing evidence to the court. After court today, I will be sending that over to my victim advocate. And also noting that this was in public, he doesn't care who sees him. He doesn't care what he does. He doesn't care what the court says. He's going to continue to cause destruction if he's not sober and he doesn't have severe mental health intervention. And I don't think he can be sober without going to jail. So I ask that the court invoke the maximum bond possible. And that's all, Your Honor.
Thank you for being here, Ms. Taft.
Thank you.
Right, Ms. Cousins, would you like to speak? Okay, why don't you come over here to where the district attorney's table? Right, just start by saying your name, please.
Georgia Cousins.
Okay, what is it you want me to know, ma'am?
I was just hoping for PR bond from my side and full contact if I could.
Okay, thank you, ma'am. Go ahead and have a seat.
How about
All right,
that?
Mr. Burkett, I wanted to just to take a moment because with all these active cases, it takes a while to be able to get all the accurate information. Let me start first with 19 CR 2947. That's a case that you've been on probation for assault in the third degree as an act of domestic violence. The victim there is Ms. Ratliff. And during the time frame of that case, obviously, four new domestic violence allegations have occurred since you've been on probation in that case. You've had your probation revoked and reinstated several times here throughout the pendency of that case. The next case is 24 CR 1564. In that case, again, you pled guilty to assault in the third degree as an act of domestic violence. The victim in that is Ms. Taff, who is here and just spoke. You've been on probation in that case, and since that case, you picked up the four new charges, and three of those have been domestic violence, allegations of domestic violence. Now I want to go through just a little bit of what's happened since December. Since December, you've picked up 26 CR 781. In that case, the allegations are from December 18, 2025. The allegations include allegations that you're a habitual domestic violence offender, third degree assault, telephone obstruction, false imprisonment, in violation of a protection order. You then posted bond. As a
This one is about to come out of left field, guys. So pay attention.
$1,000 cash surety bond on April 14. I'll note as well, you've picked up 2026 M1182. That is charged as a third degree assault as an act of domestic violence. I believe that case is in 401. That case contains allegations from February. And in that particular case, also is an allegation against Ms. Cousins. Then from April 14, you have an obstruction, violation of protection order resisting case that's also pending in 26 M2094. And now recently you picked up 26 CR 1315. This case, hold on one second. Also against Ms. Cousins, the allegations are second degree assault, habitual domestic violence offender, and other similar charges, including violation of protection order. Mr. Burkett, that's quite the mess. And frankly, the allegations here, since you've been on probation, is that you have, in the 19 CR case, you've been convicted in one case, and now you have two new felony cases involving Ms. Cousins. And you have a misdemeanor case involving Ms. Cousins. That's three cases in less than a 6-month time frame. And that doesn't also include 26 M2094. Ultimately, you've posted bonds, and the pattern here has been that you're picking up new offenses. So ultimately, at this time, Ms. Cousins, I want you to understand, I'm more concerned about your safety at this point, because that many cases in that short of time frame is something that I'm very concerned of. So what I'm going to do in the two felony cases with probation complaints pending, since bond is being addressed in those two cases, I am going to require bond stay as it is. I do believe it's appropriate given, frankly, the nature of the fact that so many
Did he say the bond was $75,000? I can't remember.
domestic violence cases in a short amount of time. So to be clear, in 19 CR 2947, I will require bond to remain at $100,000 as a cash or surety bond. Compliance with the terms and conditions of probation will be a condition of bond. In 24 CR 1564, again, bond will be set in the amount of $100,000 as a cash or surety bond. Again, compliance with the terms and conditions will be a compliance of the bonds in those particular cases.
All right,
And
here
I'll
we
just be clear,
go.
Mr.
Get ready.
Barkat, the mandatory protection order is also a condition of bond. No contact with anyone associated with that case, either Ms. Ratliff or Ms. Taff. And that means no contact whatsoever. Because it's pretty clear from these allegations, it doesn't seem like you really care about the protection orders. That's a direct order of court. This court has ordered you not, and other courts have ordered you not to have contact with individuals. And from these allegations, it's pretty clear you're saying to us, I don't care. I'm going to do what I want. And sir, those are not put in place by any of the victims in the case. They're put in place by courts. So until this court or a different court in my position is giving you permission to have contact with those individuals, no contact. And it means just exactly that, none. There's no confusion whatsoever. You're not allowed to have any sort of contact with Ms. Cousins. And that's an order of this court. And so I modify it, you can't do it. None. And you can't have someone else do it on your behalf. No contact. In 26 CR 781, currently a bond in that case is set at $3,000 as a cash or surety bond. I will leave bond in place, but I am going to require as a condition of bond, not only compliance with the protection order, but if you're able to post all the bonds in this case, I'm going to require an active GPS monitor as a condition of bond.
Now, just so we're all on the same page, this man is in court for these charges. The judge could not have been more clear a second ago, just a second ago, like right now ago. No contact.
Right, now that we've addressed bond, Ms. Prevey, obviously Mr. Burkhart would have a right to have a hearing within 14 days on the 19 CR case and 24 CR cases. How does he want to proceed?
One moment, please.
Of course.
Thank you. We would waive the, we'd waive the right to that hearing within 14 days. We request to set out for arraignment in the 26 CR case and then a status in the two other cases, please.
Right, and I believe the other case is still pending in 302 in front of the magistrate. May I speak to Mr. Barkat about his right to have a hearing within 14 days?
Yes, thank you.
Mr. Barkat, sir, you have the right to have a hearing within 14 days. The fact you're in custody, there is a complaint that's been filed. My understanding is you're wanting to waive that right. Is that correct? Yeah. Sir, is anyone forcing you, threatening you, or coercing you in any way to be able to waive your right to have a hearing within 14 days?
No, Your Honor.
Are you under the influence of any sort of drugs, alcohol, medication, or intoxicants? Anything affecting your ability to think clearly today?
No, Your Honor.
Sir, in your own words, are you wanting a hearing within 14 days, or are you wanting to waive that right?
I'll waive it.
Okay, we'll find your decision to be able to waive your right to have a hearing within 14 days as a knowing, intelligent, voluntary decision that's not under the influence of any sort of drugs, alcohol, medication, or intoxicants, that you are thinking clearly today. Give me just one moment.
I paused it for 1 second. Because look at him. In front of the judge who is speaking to him. Can you see where he's looking right now? Dumbass.
Sir, look at me. Do not look at her again. I am not going to warn you again.
Yes, Your Honor.
I can hold you in direct contempt. I saw you look directly at her and give her an evil eye. It is not her fault that you're in custody in this moment. Do not violate the protection order in front of me again. I will not warn you again. All right, Madam Clerk, if you could give us an arraignment and status date here on the 19 CR, 24 CR, and then also 26 CR 781.
Yes, thank you.
Terry, you talking about the defendant or the judge?
Yeah, protection order. Was she back here on those dates, sir?
That judge, I'm going to watch that judge because I like that judge. Don't look at her. Okay. This poor guy has no idea why he's in jail. None. But then wait till you hear the charges.
I'm ready next on Mr. McCaster.
26 CR 1316, People versus Anthony McCaster. Entries of appearance, please.
Brave Table on behalf of the people.
Jordan Image from the Public Defender's Office on behalf of Mr. McCaster, who's appearing in person in custody.
Good morning, Mr. McCaster.
Yeah, sir.
We're scheduled this morning for preliminary demand.
Yes, we can offer July 8 and July 10.
The people can accept the 8th of July.
All right, July 8th, 1:30 PM for preliminary hearing.
And counsel, who's handling this matter?
Ms. Carver.
Thank you.
You're not gonna get anything earlier than that, please. I don't even know why I'm here.
I'm sorry, Mr. McCaster.
Don't get anything earlier than that. I don't even know why I'm here. Nobody told nothing. I went to court Tuesday and they just came and locked me up, sir. I don't even know. And nobody told me about my bond, nothing. They ain't gonna ransom.
I really want to purchase the transcripts for this hearing to see what the heck the court reporter did with that, with what he just said.
They said 8th of May. I'm homeless, sir. And they said my bond, they $250,000 in. I don't even know.
So, Mr. McCaster, it looks like you would have been advised as to the allegations against you back on June 3rd when you appeared for out-of-county advisements.
Yes, sir.
You would have been advised as to the charges against you.
Yes, sir.
And as to your rights. And so I understand that you may disagree with the charges, but you understand what you've been charged with?
Yes, sir. No, nobody gave me no paperwork, nothing. They
Okay.
told me.
Ms. Carver is going to come talk with you about your
V,
case.
thanks
It's not
for
gonna
the
happen.
cheers.
I'm saying,
Thank you.
I do have a right to talk to you, sir. Please. Is that
You do. I want to make sure you understand the charges against you. Do you understand what you've been charged with?
No, sir, at all. I went to court to sign the time for misdemeanors. As I'm leaving court, they just rushed me with charges. They didn't even see no paperwork or nothing. I still don't understand what's even going on. I don't even know why I'm in jail for.
All right. Well, I think ultimately I'm going to need to advise Mr. McCaster as to the charges against him if he is indicating that he does not understand them. I see that the charges would have been discussed back at his first appearance on June 3rd. Looks like the complaint and information was filed in advance of that on May 28th. And so what I'm going to do, Mr. McCaster, is I'm going to read to you the charges that have been filed against you. And if you've got any questions about those charges, you're welcome to ask those as soon as I'm finished. All right?
Yes, sir.
All right.
He has no idea why he's there. None.
So count one is criminal attempt to commit murder in the first degree. That is a class 2 felony. And it carries a maximum penalty of between 16 to 48 years in the Department of Corrections. That count alleges that on or about February 4th, 2026, by engaging in conduct constituting a substantial step toward the commission of murder in the first degree, you, Mr. McCaster, unlawfully, feloniously, and after deliberation, with the intent to cause the death of a person other than yourself, attempted to cause the death of Daniel Allen, That's count one. And again, that carries between 16 and 48 years in the Department of Corrections, a maximum fine of $1 million and 5 years of mandatory parole. Count two is assault in the first degree. That's a class 3 felony. It carries between 10 and 32 years in the Department of Corrections, and it alleges that on that same date, February 4th, 2026, you, Mr. McCaster, with the specific intent to cause serious bodily injury to another person, unlawfully and feloniously caused serious bodily injury to Daniel Allen by means of a deadly weapon, namely a firearm. That's count two. Count three is felony menacing. That's a class 5 felony. It carries between 1 and 3 years in the Department of Corrections, a maximum fine of $100,000 and 2 years of mandatory parole. And it alleges that on that same date, you, Mr. McCaster, by any threat or physical action, unlawfully, feloniously, and knowingly placed or attempted to place Daniel Allen in fear of imminent serious bodily injury by use of a firearm. So that's count three. Count four is theft from the person, a class 5 felony. Again, that carries between 1 and 3 years in the Department of Corrections, a maximum fine of $100,000 and 2 years of mandatory parole. And it alleges that on the same date, you, Mr. McAllister, unlawfully, feloniously, and knowingly took a thing of value, namely jewelry, from the person of Daniel Allen. The last 2 counts against you are crimes of violence. Those are sentence enhancers, and essentially they allege that counts 1 and 2 were committed in a manner that caused serious bodily injury to another individual or involved the use of a deadly weapon. And ultimately, those sentence enhancers result in the enhanced sentencing range, as I discussed with you a moment ago. So do you have any additional questions about the nature of those charges against you?
Yes, sir.
Okay. So what we've done is set your case for a preliminary hearing, and that'll be the date of your next appearance. That hearing is where the people have to show probable cause as to each eligible count in your case.
I don't think it has carpet at all. I think it's all flooring.
Do you have any additional questions for me at this point?
No, sir.
All right. Anything further from the people on this case?
I do know in one bedroom the walls are black, and in another bedroom, the walls are this green screen color. So I told the kids I'm going to take the room with the green screen wall because that's just going to help. That's just going to help me. And my internet isn't there yet, but I'm not there yet. So hopefully my internet gets in time for me to stream on Tuesday.
No, Your Honor, thank you.
And anything further from the defense?
Thursday?
No, Your Honor, thank you.
A day. Whatever day it is that I come back. Okay, so my son would do this. That's why I got this clip, because my son would absolutely do this. My son's probably going to get the biggest room. My daughter wants the littlest room. That's what she wants. That's what she likes. And I'm going to get the green screen room.
Thank you. 26 CR 50, Brian Calva Dawson.
Marian Noich for the people.
Page here for Mr. Calva Dawson, who appears in person and on bond by my side. I did file some paperwork in the case this morning where Mr. Calva Dawson would be entering into requesting that the court accept entry into a deferred sentence. And that would be to a class 5 felony menacing.
I agree.
All right, thank you. Can I have the district attorney make a record regarding Victims' Rights Act compliance first?
Your Honor, we're compliant with the
carpet is
Victim Rights
lovely.
Act, specifically regarding
Very
today's
professional.
court date through best efforts, but we have had contact with the victims in this case earlier on. But most recently, after having confirmed with the defense that this would be pleading and going to immediate sentencing today, I did attempt to let the victims know that, and I was not able to positively contact them. Again, I have exercised due diligence though, so I believe we can go forward.
Okay, thank you. Mr. Calva Dawson, good morning.
Good morning.
On your behalf, your attorney.
Also, mods, my house is rural, way out in the country. Pretty far out in the country. Oh, the carpet sort of matches the ceiling as well. That's a very professional looking courtroom. I like it. But, so I don't know if I have cell coverage where I'm moving to yet. So, I don't know. I won't be at work. I took off work for 4 days too. So if I'm not at work and I don't have cell coverage and I don't have internet yet, you will not be able to get a hold of me for 4 days because I won't have internet. Which, I guess I'll churn some butter or something if I don't have internet for 4 days. But I'm not like gonna go into town to get internet. I'm too lazy for that. I won't be. So if you don't hear from me at all, that's why.
Filed a plea agreement, and it states that you'd like to resolve your case today by entering into a guilty plea to count 1, menacing the Class 5 felony. That would be subject to a 2-year probationary sentence, with the terms and conditions being all the standard terms and conditions of probation and those that are outlined in the consent for entry of deferred sentence agreement. Is that your understanding of the plea?
Yes, ma'am.
We're accepting your plea. I'm going to go over these agreements with you. If you have any questions while I'm doing so, please let me know. If you need additional time with Ms. Hare, let me know that, and I'll make sure that you do have that, okay?
Yes, ma'am.
The alternative to entering into this plea agreement today is that you are entitled
How's Texas, Michael? I missed you.
to maintain your presumption of innocence to these charges. That presumption of innocence continues unless and until the prosecution proves each and every element of the charged offenses beyond a reasonable doubt. You have the right to have an attorney represent you. You have the right to enter a plea of not guilty and demand a public and speedy jury trial on the criminal charges, as well as on any sentence enhancing or aggravating factors. You have the right to have your attorney cross-examine all witnesses brought by the prosecution. You have the right to present a defense at the time of your trial and bring in witnesses under court order to testify on your behalf. Additionally, you have the right to testify, or you may choose to remain silent, and your silence cannot be used against you. Additionally, if you were convicted following a trial, you would have a right to appeal any conviction to the Court of Appeals. Do you understand these trial rights?
Yes, ma'am.
And do you understand you give up these rights by entering into this plea today?
Yes, ma'am.
Can you tell me how old you are, please?
21,
What is the last grade of school that you completed?
a high school diploma.
Therefore, do you read, write, and understand the English language?
Yes, ma'am.
Plea agreement that I have has electronic initials and signature on it. Did you authorize your attorney to place those on this plea agreement?
Yes.
And did you do so after you reviewed it in its entirety?
Yes, Your Honor.
And did you understand everything that you reviewed?
Yes, Your Honor.
Today, are you under the influence of any alcohol, drug, or other medication that would affect your thinking?
No, ma'am.
Do you feel like you are thinking clearly today?
Yes, ma'am.
Have you had enough time to discuss this case and this plea agreement with your attorney?
Yes, Your Honor.
And are you satisfied by how you've been represented in this case?
Yes.
Do you understand that a guilty plea admits to the charge?
Yes, ma'am.
You're pleading guilty to menacing, a Class 5 felony. It reads, on or about January 7th, 2026, Brian Enrique Calva, by any threat or physical action, unlawfully, feloniously, and knowingly placed or attempted to place Jessica Sereny and Jose Hernandez in fear of imminent serious bodily injury by the use of a firearm in violation of 18.3206 of the Colorado Revised Statutes. Did you review the legal definitions that apply to this offense?
Yes, ma'am.
Do you understand what you're pleading guilty to?
Yes, Your Honor.
On a Class 5 felony, the presumptive sentence if incarcerated is 1 to 3 years in the Department of Corrections with a 2-year parole period and fine of $1,000 to $100,000. With exceptional circumstances, that range is 6 months to 6 years. With extraordinary aggravating circumstances, the range is 2 to 6, and with sentence enhancing circumstances, it's 1 to 6 years. Do you understand all the possible sentencing ranges for this Class 5 felony?
Yes, Your Honor.
In this case, it's being proposed that you receive a deferred judgment and sentence on the Class 5 felony. That's subject to the terms and conditions that are outlined in the deferred sentencing agreement. Did you fully review that?
Yes, Your Honor.
And do you
You're the co-worker. We have an original Michael. Michael, psycho. You are a co-worker.
understand if approved by the court, those will be requirements of your probationary sentence?
Yes, ma'am.
Is anyone forcing you, threatening you, or making you any promise in exchange for entering into this plea agreement?
No, Your Honor.
Are you doing so voluntarily, meaning that this is what you want to do?
Yes, Your Honor.
Have you ever served in the United States military?
I have not.
And do you understand if you're not a United States citizen, any guilty plea or conviction may have immigration consequences?
Yes, ma'am.
Do you have any questions for me or your attorney before I take your plea?
I do not.
As to count 1, the Class 5 felony of menacing, how do you wish to plead? Guilty or not guilty?
Guilty.
Court accepts the guilty plea tendered to Mr. Calva Dawson. I find he's intelligently waived his rights incidental to trial on all issues. I find that he understands the nature of the offense, the elements of the offense, and the consequences of entering into the plea, including the applicable sentencing range. I do find he's tendered a knowing, voluntary, and intelligent plea without undue influence or coercion. I'll accept the waiver of the establishment of a factual basis for purposes of the plea. I'll also note that Mr. Calva is present in person. He does present as alert and coherent. I do find he understands his plea agreement. I also find VRA compliance for the plea. I accept his guilty plea to count one. We'll proceed to immediate sentencing, and I'll start with you, Ms. Hare.
I'm asking the court to accept the proposed agreement here. Mr. Calva is 21 years old. On his record, there's one juvenile matter that was ultimately expunged from back in 2016. So there has been a significant time that has passed since he's had any engagement in the criminal justice system. He is extremely close with his family. His mother's been present with him at every court date that he's had. He has a very significant relationship in his life. He's been with the same girl for over a year now at this point, who has 3 children that he helps care for. He also has a younger brother who's 14 years old and has autism. And when I've talked to Mr. Calva about what his life looks like, it sounds like it really revolves around all the kids in his life and helping care for those kids. Mr. Calva, I know in speaking with his family, that's something that they've really emphasized. He is really regretful of this. He is looking forward to the opportunity of getting this off his record if the court accepts this agreement, and we're asking the court to accept the proposed disposition today. Thank you.
Thank you. Ms. Noich.
Your Honor, I'm also asking the court to accept the proposed disposition and the consent for entry of deferred sentencing. I'll note that it appears that this case stemmed from, I think Ms. Hare correctly summed it up, showing off, but also just bad choices and maybe behavior that's fueled by immaturity. It sounds like the defendant, even when he was contacted by law enforcement, was posturing in a way. He admitted to officers that he had been drinking. He stated that he was involved in a gang. He did state that the gun wasn't his, and ultimately did admit to shooting the gun off twice into the air to see how the gun worked. Portions of this incident are on video, and
he shot the gun in the air to see how it worked. Now he's in court. My son would do that. He just would.
One of the more concerning pieces of this crime, there's a video of a driver behind the defendant's vehicle, and it does show the defendant, or at least the person in the passenger side of the vehicle where the defendant was ultimately contacted on the passenger side, sticking his hand out and firing some rounds into the air. And so I think this is one of those cases where it's really up to the defendant to turn this around and not do something like this again. I mean, as obviously the defendant is aware and the court is aware, this will be up to the defendant in terms of how this sentence ultimately resolves. If he's going to have a conviction for this behavior or not, it'll be up to him to work it off. And given his young age and the complete, I'll say complete lack of criminal history, he does have that juvie expungement that Ms. Hare referenced, but otherwise he doesn't have anything, and he doesn't have any prior police contacts. I think it's an appropriate resolution, and so I'm asking the court to accept it. Again, I will note this does seem like a crime that was sort of fueled by bad choices and bad decisions, and just maybe a lack of just thinking through how this would affect everybody in the community. Thank you.
Thank you. Mr. Calva-Dawson, you have the right to make a statement if you'd like to before your sentence. Is there anything you wanted to say or have me know?
No, ma'am.
All right. Court's reviewed the court file in this case. I've considered the arguments of counsel and the sentencing factors at 18-1-102.5. I'm not sure what you're doing with a gun, Mr. Calva-Dawson, but you shouldn't have one, and you shouldn't be firing one. You shouldn't be firing one in a public parking lot, particularly after you've been drinking. All of that just seems like a totally dangerous and unnecessarily risky situation. This is an opportunity for you to avoid a felony conviction on your record if you're successful, and I hope that you are. You got to take it seriously, though, and lock in on it and do everything that's required of you. If not, you come back to another courtroom and you answer to that, and then there's fewer options than probation. The court will impose a 2-year probationary sentence in this case on count 1. They'll be subject to all standard terms and conditions of probation. Additional special conditions will be those that are outlined in the consent for entry of deferred sentence. The court will dismiss the unprosecuted count in this case. We'll note that there's no restitution. There are court costs applied. We'll set a 2-year review on compliance with this sentence. Is there a handgun that needs to be forfeited?
No, Your Honor, I believe, I think both parties agree that the gun did not belong to Mr. Calva.
Okay.
I think that's correct. I think if the gun was seized in relation to this incident, it does need to be forfeited, but I don't know that, again, that it belonged to him.
Okay. So we'll set the review hearing on Thursday, June 8th, 2028. If you're successful on this, Mr. Calva, the probation department will file a notice with that, and then the felony conviction will not enter. There's just a notice of compliance, and that the district attorney will move to dismiss that count. If you're non-compliant, you'll receive notice of that either through a summons or a request for a warrant through the probation department. You'll get an order here in a moment. It will direct you down to the probation department on the 3rd floor. You need to check in with them there, set up your orientation. They'll go over the same order with you. Do you have any questions regarding your sentence?
No, Your Honor.
Okay. Good luck to you. We'll have you come up and sign that as soon as we have that printed and ready for you. All right? Which I think is now. Thank you.
Kids. All right, we got one more clip. Then we're done. This girl.
I'm ready on Ms. McInnes.
Okay. The court will call 26 CR 3A4, People versus McInnes.
Chris Johnson for the people. Your Honor, this wasn't in the paperwork. There's a warrant misdemeanor case that I'm going to dismiss as part of the plea. If the court's willing to hear it, it's 26M 1323.
Okay. The court will also call 26M 1323. And enter appearance for defense.
Oh, apologies, Judge. Megan Quantock on behalf of Ms. McInnes. She appears here in person in custody.
Thank you. Good morning. We're set today for an arraignment, but it looks like we have a plea. And also looks like we're saying over for sentencing. Is that correct?
That's correct, Judge. And then a request about bond as well.
Okay. And so, Ms. McInnes, it's my understanding you wish to enter a plea of guilty today. Is that correct?
Yes.
Okay. And I do have plea paperwork signed by Ms. Quantock, and she also signed it for you. You gave her permission to do that.
Yes.
Okay. And when you went over this plea paperwork, did you understand everything that you and she talked about?
Yes.
And do you need any additional time to meet with her?
No.
Okay. And are you thinking clearly today?
Yes.
Are you under the influence of any drugs, alcohol, or medication that would make it difficult to understand?
No.
Okay. And Ms. McInnes, you understand that if you enter a plea of guilty today, you're waiving a number of rights. Do you understand that?
Yes.
And all of those rights are contained in your plea paperwork. Do you remember going over those?
Yes.
Okay. And I want to highlight a couple. You understand you'll be waiving your right to have a trial, waiving your right to have district attorney's office prove beyond a reasonable doubt the allegations against you, your right to present your own defense, and your right to remain silent, among many other rights. Do you understand that?
Yes.
And the plea today, as I understand it, will be to count 2, assault in the second degree, a class 4 felony. Is that your understanding as well?
Yes.
Okay. In your paperwork, there's a description of what it means to have committed that offense. Do you remember going over that?
Yes.
Do you want me to go over that description, any definitions or elements with you?
No, thank you.
Okay. And Ms. Quantock, waiver reading of the elements?
I do, Judge. And I realize I apologize about the paperwork. I fixed it from what the people had sent me with their agreement. Our intent here is to plead to the subsection C count, which is actually count 1, which was a little bit confusing because it's a lower count than counts 2 through 6, which I believe is where we got confused. But I'm now seeing on the paperwork, some say count 2, some say count 1, but they all have the correct subsection, which is C. And then the motion to dismiss that I filed this morning dismisses counts 2 through 6.
Okay. You read my mind as to my next question for you. And Ms. McInnes, in your plea paperwork, there's a description of all of the possible consequences. Do you remember going over those?
Yes.
Okay. And I understand that the parties are going to set over for a PSI and screens, in that if you're accepted to a treatment court or community corrections, that would be the recommendation of the people. But you understand ultimately any sentence is up to the court.
Yes.
Okay, and I could sentence you to probation. Probation could include participation in a treatment court. It could include up to 90 days in the county jail or 2 years of work release. The court could also sentence you to community corrections if accepted, or to the Department of Corrections. If sentenced to the Department of Corrections, it'd be for a period of time between 2 and 6 years. Do you understand that? And the court would also order a mandatory period of parole of 3 years. Do you understand that?
Yes.
Okay. And then do you also understand that the court will impose the standard fines and fees as well?
Yes.
Okay. And knowing all of those potential consequences, do you still wish to enter a plea of guilty today?
Yes.
Okay. And any additional advisement from defense?
No, Your Honor, thank you.
Any additional advisement from the people?
No, Judge.
In a factual basis, please.
Thank you, Your Honor. So on February 15th, 2026 at 5:18 p.m., this law enforcement responded to 4401 Teller Street, Unit A2. Police had been called because Miss McInnes had stolen from King Soopers. She also had 3 warrants at the time. The misdemeanor case I dismissed was a theft from Alto that occurred the same day as well. When law enforcement tried to take Miss McInnes into custody, she tried to run inside. She had to be pulled out of the apartment. She refused to walk and went limp and had to be carried out. She kicked Officer McLean multiple times and tried to bite him. That's the basis of charged counts 3 and 4. She scratched Officer Rayleigh and also bit him. That's the basis of counts 1 and 2. At one point, she slipped her handcuffs in front of her body and unbuckled her seatbelt. She then wrapped those chains around one of the peace officer's wrists. And according to the affidavit, she kicked and scratched almost every officer assisting in applying the restraint. I'll mention it now, but if I can reiterate it as a basis to accept the plea, she was on an open deferred judgment for second-degree assault on a peace officer in Arapahoe 24 CR 2530. Other than those 2, she just has generic vagrancy type shoplifting offenses. Obviously, if she had just been taken in on the thefts here, she would have been in county court. Her behavior obviously escalated things, and given she was on a deferred judgment for an attempted assault on a peace officer, I felt pretty hamstrung about being able to give offers in this case. She is accepting one that is not a mandatory 10-year DOC sentence.
Okay. And so, Ms. McInnes, is that what happened to support your plea?
Yes.
Okay. And so to count 1, assault in the second degree, a class 4 felony, how do you wish to plead? Guilty or not guilty?
Guilty.
Right, the court will accept Ms. McInnes' plea of guilty, finding that she's making a knowing, intelligent, voluntary waiver of her rights with the assistance of counsel, and a knowing, intelligent, voluntary plea. There is a factual basis for the plea, and the court will accept the plea of guilty to count 1, enter judgment on that count, and dismiss any remaining counts. And people are also moving to dismiss 26M1323. The court will grant that, but please file the motion as well. And we need to set over for sentencing, and there's a request to modify bond. And so people's position on that.
And Your Honor, defense counsel can make a more lengthy record. We've been discussing this last week. Apparently there's issues with the screens while she remains in custody. Given that she had 3 warrants when she was arrested, I have concerns about her being able to follow through with PSI and screens out of custody. However, given that I'm not objecting to an alternative to Department of Corrections if accepted for either community corrections or an alternative court. I wouldn't object for that reason. Obviously, that's going to have a huge impact.
I would love to see the body camera on all of the officers.
Probably on this court sentencing if she's unable to follow through with that. So that'll definitely be a test for her about whether she'd be deserving of that sentence or not.
Okay. And from defense.
Thank you, Judge. We would maintain the request that we made in our motion. Essentially, the reason being there that Ms. McInnes would be unable to get screened for behavioral health court, which is one of our screens we'll be requesting from the court if she remains in custody. My understanding is it's a Medicaid issue and that they can't do the evaluations in custody. I know this is a newer procedure that at least I haven't dealt with yet, so I did file that with the court, the email that we have received to show what I believe is the requested procedure right now. Ms. McInnes does have a place to stay with her sponsor here in Arvada, and does certainly understand the importance of being able to make it to that screen if the court allows her that opportunity on bond. I will also note that she does have a bond on her Arapahoe case that she will either have to post, or first and foremost, she'll be requesting that they modify her bond as well for this screen. She does have court there on the 15th, so she will remain in custody for at least that additional week, and it may remain in if unable to post that bond, but she certainly has been unable to post this $10,000 cash or surety bond. So to give her the opportunity for what I think would be a really good ultimate sentence, but she of course can't even ask for that without the screen, we would ask the court to modify bond here to allow for that, and she's happy to follow any condition the court imposes, to include pretrial supervision and of course the condition of completing that PSI and eval.
Okay. Court will modify bond
Friend, she would have to scrape the white out off first.
to a personal recognizance bond at this point in time. Court will order pretrial services and monitored sobriety in compliance with any mental health treatment. Court will also order compliance with the PSI and screens. The court will order a PSI. Court will order a screen for behavioral health court. Court will also order a screen for ICCS. And Ms. McInnes must check in with pretrial services within 24 hours of bonding. Court is also going to find good cause to maintain the public defender's appointment pending sentencing. I don't want to get in a point where we didn't get an application, we're having to continue again. So the court will find good cause to continue that appointment without further application. And I think we probably need 6 weeks, but when do you anticipate her Arapahoe case addressing bond?
I anticipate that she addresses that next week on the 15th, which is next Monday.
So let's plan on 6 weeks from then, which probably gets us to our August 3rd date. Does that work?
That works for defense.
Okay.
Thank you.
So we can set on August 3rd, and let's set at 9:30. Ms. McInnes must appear in person if she's out on bond.
Okay, thank you, Judge.
Anything else to address today?
You should see the dismissal paperwork for the misdemeanor in your inbox, Judge.
Yeah.
Push it through. Thank you. And I have nothing further.
Thank you.
All right, first I'll address Snoopy, then I'll address Brent and Monica. Snoopy, yes, she does have a PR bond. That's only because they just changed the competency and mental eval laws in Colorado, like this week, last week. So that she can't get the help that she needs mentally if she's in custody. So she has to be out on a PR bond. But a condition of her PR bond is to go and get that mental health evaluation and follow whatever they say, which probably means she's going to stay in there for a bit. So she's not just out on PR bond. The judge had to do that to get her the mental health part that she needed because of the new laws that just changed, like really recently. And yes, you don't hear Monica say she's wrong hardly ever. And it's not because she can't say it. And it's not because she won't say it if she's wrong. She's just never wrong. So she has no reason to say she's wrong. That's why we never hear it. But she's an adult. And when she's wrong, she says, hey, I'm wrong. And I was with her because I was thinking the same thing, but that's That's YouTube. YouTube is the YouTube emotes, and then the circle, and then so I was right there with her. I was wrong right alongside of her. Then I decided to just peek into my Twitch, and then we realized, sugar, that's the wrong thing. But that's why you never hear Monica say she was wrong. It's because it's just rare. It's just a rare thing, you know? Snoopy, on the other hand. Alright, guys, I know it was a short one today, but that's all. I ran out of time. That's what I found. I found an hour and 20 minutes worth of stuff instead of 2 hours. But some days it be like that. Some days it's 4 hours long. I'm not wrong. I'm never wrong. What? Shut your mouth. Who do you think you are? Come here. 1v1 me. Tell me I'm wrong. I will see you all again in 22 hours. With more court cases. And then one more day, and then I'm off for 4 days. 4 days. I'm off for 4 days. And y'all are going to forget about me completely. And that's fine. It's fine. You all get up way too early to begin with. You know, you can watch these things like later in the day. You can replay crew these. But I will miss you. But I'll see you tomorrow. Bye, guys. Behave, okay? See you soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guarantee.